If you have a revocable trust and haven't renamed your assets but are joint, will they still go into probate or will they automatically go to the joint owner? There's essentially three ways to avoid probate. Way number one is to own joint assets. So owning things with a spouse or another person as joint tenants or joint owners with rights of survivorship. Way number one. Way number two is listing beneficiaries on everything you own, or a POD, payable on death, or TOD, transfer on death recipient, depending on the type of asset. Some assets you name beneficiaries, others you do a POD or a TOD. The third way is to set up a living trust or a revocable living trust. It's revocable because you can make changes to it during your lifetime. We call it a living trust simply because you're alive when you form it. It's not a testamentary trust, which is formed through your will after you've passed away. Okay, so of those three ways, jointly owning assets, listing beneficiaries, or creating a revocable trust, the revocable trust offers the most peace of mind because it can account for any scenario. So, in your question, are joint assets protected from probate? Yes, they're protected from probate at the first level, meaning when your spouse passes away, or if these are assets owned together, with your spouse, when one spouse passes away, there won't be a probate for the other spouse. Or even if they're jointly owned just between two individuals as joint tenants, same thing. When the first person passes away, we're not going to see a probate. However, once the owner is left as a sole owner, so there's just one person who now owns the asset because the other joint owner passed away, well, there is going to be a probate when that person passes away, which is often why people, when they form a living trust or revocable trust, they then retitle the assets into their trust because normally the asset ends up going to the other joint owner for their lifetime anyway, but then you have the added protection of it trickling down to other beneficiaries without having to go through probate. I see all sorts of scenarios where one spouse passes away, the other spouse is totally distraught and not in any condition to try to retitle assets at that time. Sometimes that spouse passes away shortly after the surviving spouse passes away shortly after the spouse who passed away, never got the opportunity to put the asset into your trust, so now you are looking at a probate. Or, although this doesn't happen frequently, there are scenarios where people die simultaneously. They're on vacation together, or they're scuba diving together, or they're in a car accident together. And in that scenario, if joint owners of an asset pass away together, then there's going to be a probate. So this is why a trust, which can account for any eventuality, meaning you have a situation like that, or you have another crazy situation that pops up, your trust can say what to do under that scenario. So it's going to avoid probate at many levels, not just at one level, which even in order to avoid it at that level, everything has to be perfect, meaning you live a long life, one spouse passes away before the other, and then the other spouse has plenty of time and is able to actually then do something with the asset to have it prevent probate when they die. My vote is if you already have the joint trust in place, it's a good idea to start funding the trust now. Funding the trust means transferring the assets into the trust by retitling them. If the goal is for the surviving spouse to own all the assets first before they go to the beneficiaries, just make sure that your trust is set up that way. It probably is, but the sooner you move those assets, the more peace of mind you're going to have because you really don't know what's going to happen, and the last thing you want is to unwittingly be in a scenario where a probate is going to be required. All right, I hope this helps. If you have any other questions about the ways you can avoid probate or jointly held assets, estate planning, asset protection, elder law, probate. And if you're in Florida, please contact our office. We're in Clearwater, and the link is in my bio.